If you guys have any questions in the meantime, just yell. I should be here, and I'll be here in the background just in case anything goes awry.
Can I just double check that you can hear me?
Yep, we can hear you just fine.
Great, thanks so much.
Hey, Deja, are you there? I just want to make sure I say your last name correctly.
Yes, it's Ostrowski.
Ostrowski.
Yes. Thank you.
I think we covered this in the test run, but you guys want me to read you the questions towards the end, correct?
That's what I would prefer. Thanks, Danny.
Okay.
Yes.
Go ahead and do that. Okay, it is 1:30. We can get started. Thank you everyone for joining us today. This is a session for understanding tenants' rights, how to better serve tenants who may need help. This is our last breakout session of the day, so thank you for joining us. Just a little description about the session today. The session will provide a basic training on tenants' rights in Hawaii and will identify the resources available in our community that can help. I would like to introduce our two speakers that we have on our panel for today. We have Stephen Levins. He is the Executive Director of the State of Hawaii Office of Consumer Protection, the state agency primarily responsible for enforcing Hawaii's consumer protection laws. We also have Deja Ostrowski. She is a staff attorney with the Medical Legal Partnership of Hawaii. She addresses the complex social determinants of health that impact our well-being. So welcome to the both of you. Thank you for joining us today. And without further ado, I'll turn it over to Stephen.
Thank you very much. I'm going to try to share my screen now, and hopefully that can be done without a problem. Is it on?
Yes, we can see it.
Okay, great. All right, again, thank you very much for inviting me. And I'm going to give a overview of the Landlord-Tenant Code and the Office of Consumer Protection's involvement with it. First, I'd like to say that it's kind of a standard disclaimer that these opinions are my own and don't necessarily reflect the position or the opinion of the state of Hawaii or the Department of Commerce and Consumer Affairs or the Office of Consumer Protection. So what I hope to talk about this afternoon is a little information about the Office of Consumer Protection, OCP. We have the Residential Landlord Tenant Information Center in our office, and I'll talk to you about that. And also issues that may arise involving the landlord-tenant issue, tenancy. So we'll kind of break it into three areas: issues involving tenancy before they actually occur, during the tenancy, and after the tenancy. And then at the end of, I believe, both of our presentations, we're going to have time for questions and answers. So first, the Office of Consumer Protection, as many of you probably already know, is a division of the State of Hawaii Department of Commerce and Consumer Affairs. And unlike in virtually every other state, where the function of consumer protection is lodged in the Attorney General's office, Hawaii is unique in which it's lodged in the Department of Commerce and Consumer Affairs. So we're the primary agency responsible for reviewing, investigating, and prosecuting allegations of all issues involving unfair, deceptive trade practices in consumer transactions. Other things that we do can provide consumer education, which hopefully we're doing right now, and promote awareness of consumer protection issues through programs and educational materials. We have four sections. So we have a Consumer Resource Center, which is an intake section. We have investigation section, which we have trained investigators in that section. And in fact, the supervising investigator is graciously agreed to join me this afternoon, Sassy Faldo, who will be available to also help provide answers to some of the questions that you folks may have. We have a legal section that enforces violations of Hawaii's and also federal consumer protection laws. And last but not least, is we have the Residential Landlord Tenant Information Center, where we have OCP investigators and volunteers manning the telephone lines Monday through Friday. And we like to say it provides sort of neutral information. We don't advocate for a tenant. We don't advocate for a landlord, but what we do is provide information that's contained in the landlord-tenant code. The hours of the information center are 8 to noon. If someone calls after that time and leaves a message, it's responded to the following morning in order of when they were received. If there's an urgent issue and someone calls the general number, we won't turn the caller away. It will be addressed. Similarly, if someone walks into the office after 8 to 12, if there is someone available to speak to the person who's generally a distressed tenant, we will take time and talk to them. And this is just the telephone number, contact information. Slide is self-evident. We also don't turn people away if they don't speak English. We have a contract with a translation service. So if someone is calling the office and language turns out to be a barrier, we facilitate the interaction by contacting this translation service, and that is obviously at no cost to the caller, and we will bear the cost of that. We also have a Braille for sight impaired people for the landlord-tenant code available. Okay, so this is a kind of an interesting slide that is somewhat accurately reflective of what we've seen during the past year or so involving people who call the landlord-tenant line. So you see that it's skewed in favor of tenants. So more tenants call than landlords, to the tune of 56% to 38%, and other callers who don't fit into that criteria, it's a small percentage. So most of the calls that we receive are from tenants. The common issues that the tenants call us about involve security deposits, issues involving repairs, lease termination, problems associated with accessing the premises, and insects and rodent issues. Now, when landlords call, their focus is on terminating leases and accessing premises. They have issues, the tenant is not allowing them to access the premises, or they have questions about, they want to terminate the lease.
Sorry, Stephen, can I interrupt real quick? Did you want to share your screen as a slideshow so everyone can see the full size of it?
Yes. I don't know how to do that though.
Go to the top where it says slideshow. And then click on that. Right at the top, right here. At the very top right here, it says slideshow.
I'm not showing that screen on my.
Okay. I mean, we can still kind of see it. I mean, it's just a little bit smaller. It's not showing.
I have some assistance here. Oh, okay. Is it working now?
It looks the same. It's not showing the full slide on the screen.
Yeah, we have it in at slideshow right now, but it's not showing on your side for some reason.
Oh, okay. Maybe it's just my side then. I just want to make sure. Sorry about that.
That's okay. Are you able to see the slides?
I can see it on my side.
Okay.
Yeah, we can see.
Okay, I'll just continue then. Sorry. I may know the landlord-tenant code, but this is the PowerPoint is sometimes a mystery to me. Anyway, so that we enforce the code, okay? So it's contained in chapter 521 of the Hawaii Revised Statutes. And the purpose of the code is to encourage landlords and tenants to maintain and improve the quality of housing in Hawaii. One of the other things that we've done over the years is produce a landlord-tenant handbook. I think that this has been around for at least 30 years, probably longer. It has a lot of extremely helpful information explaining the various sections of the landlord-tenant code and some other issues associated with landlords and tenants in Hawaii. And we have it available for free online, or if you want an actual hard copy, we're able to provide that for essentially our cost, which is $2. And you can come and get it in person, or you can you can get it through the mail. Okay, so the landlord-tenant code covers, pretty much everything involving landlord-tenant relations in Hawaii, but there are exclusions. So not every landlord-tenant relationship in the state is going to be covered by the landlord-tenant code. Now, it doesn't mean that tenants don't have rights that they can assert. It just means that the chapter governing the landlord-tenant code does not apply in these situations. So, if you have a dorm room at UH, or you're in a long-term care facility, you're in the hotel, those situations are excluded. Some of homeless facility, public housing projects managed by Hawaii Public Housing Authority, transitional housing for abused family or household members, and HPHA controlled state properties. Again, those are not subject to the landlord-tenant code. So these are some of the issues that we encounter before the tenancy is actually entered into. And we become aware of these through people who contact us. People call us and they have concerns about discriminatory practices on behalf of landlords, unreasonable screening and application fees, issues relating to financial privacy, and issues relating to how much money has to be provided to obtain a unit. One of the things involves Section 8 housing. Currently, the landlord-tenant code doesn't address the source of income discrimination. There have been attempts by the legislature to remedy this issue, but as of right now, it's still not covered in the landlord-tenant code, and I don't believe it's covered under the civil rights statutes. Another issue, now this is again pre-tenancy, application screening fees. This isn't a problem that we've seen over the years, in which maybe some unscrupulous landlords or their agent are just charging screening fees multiple times with no intention of renting the unit to the prospective tenant. There have been bills introduced in the past few years, some of which that we have endorsed, and trying to limit the amount of the application screening fees. Right now, there's actually no amount that is limited by statute here in the state of Hawaii. So, you can charge someone, or you can try to charge someone $100 or $200, despite the fact that it may only cost the agent or the landlord $25 to do the credit check and other other checks associated with the application. Another issue is review of financial assets. Can a landlord ask for bank information when applying for a rental unit? This comes up quite frequently, but the landlord tenant code, again, does not specify the types of documents that are accepted or acceptable for proving creditworthiness. The applicant can submit redacted copies of their financial statements. We tell people to ask if there is alternative ways of proving assets and income if they're reluctant to provide certain documentation. And if the applicant is uncomfortable with providing certain financial statements, if the landlord, if the landlord or their agent is asking for things really that are inappropriate, again, there's nothing specifically prohibiting them from doing that. But if they're asking for stuff that they shouldn't, that the tenant believes so that they shouldn't be asking for, then they can move on to the next application. The issues regarding deposits and non-occupancy, if you put a deposit down for a place, but for whatever reason you decide not to move in, this is a question we get all the time. Can the landlord keep my money? And under the code, the applicant will be liable for the lesser of all monies deposited with the landlord, 1 month's rent, or rent accrued from the agreed date for the start of the tenancy until the unit is re-rented. If the unit isn't ready for occupancy, what if the landlord fails to have the unit ready for occupancy at the beginning of the agreed term? The tenant doesn't have to pay rent during the time the tenant can't move in. And the tenant can notify the landlord and terminate the rental agreement anytime during the period the tenant is unable to move in. If the tenant is out, they can out monetary amounts. They can recover reasonable damages for the cost of securing alternative housing, either filing a lawsuit. If the tenant eventually takes occupancy, by taking the difference between the cost of alternative housing and agreed upon rent. And you obviously have to provide documentation on this stuff. This is another issue that comes up all the time, is how much of a deposit can be asked of the prospective tenant. The code allows for the first month's rent, a month's rent representing the security deposit, an additional deposit for a pet deposit, which can be up to a month's rent. So you see that this can be a substantial financial burden on a tenant. For instance, if the rent is $2,000, you're talking about potentially $6,000 if they have an animal. If there is a assistance animal for the tenant with a disability, then they cannot ask for the deposit for pet damage. Now, the issues regarding once a tenancy has been established, the landlord's obligation is you have to have the unit ready to move in and agreed upon, and I think agreed upon time and the condition. You got to provide safe and healthy premises, and you got to make all repairs to keep the premises in a livable condition. You need to comply with all applicable building and housing laws, keep common areas clean and safe, make all necessary repairs, and keep the premises in a habitable condition, and maintain all electrical, plumbing, and other facilities and appliances supplied by the landlord in good working order and condition, subject to reasonable wear and tear. The tenant has obligations too, of course. They have to keep the dwelling in clean and fit condition, obey the laws and regulations governing cleanliness, pay the rent on time, and if receiving public assistance, the tenant may change the rent due date to within 3 days after the mailing of the public assistance check. Tenant also needs to inform the landlord of the repairs that are needed. Notify the landlord if you're going to be absent more than 20 continuous days, and allow the landlord reasonable entry into the unit to inspect, repair, and show the dwelling. Can't just be locking out the landlord for no reason. Obviously, if you have someone who has COVID and the landlord wants to come in, that, in my view, would be a reasonable, a reasonable reason to deny entry. The tenant has a duty to maintain the unit, responsible to keep it clean and safe, properly use appliances, plumbing fixtures, comply with all the house rules, and responsible for damage to the unit by themselves or guests. This is the slides relating to the access to the premises. The landlord can enter to inspect the premises to make necessary and agreed repairs, to show the unit to prospective buyers, mortgagees, or tenants. Obviously, the landlord cannot abuse this right to just harass the tenant. 2 days notice has to be given to the tenant unless there's an emergency. So you can't just, the landlord can't just be showing up unannounced, say, I want to come in for, to show the property to someone else, or I need to do this repair or things along those lines, unless it's really an emergency. And again, the tenant cannot unreasonably deny access to the landlord. The tenant has rights, obviously, and if the landlord goes ahead and tries eviction proceedings, these are some of the main defenses that a tenant has. You can't try to kick somebody out because they complain about required repairs. That's called retaliation, and that is prohibited by the code. If the landlord failed to provide termination notice according to the law, that is a defense that a tenant has when they go to court, or if the landlord has failed to provide adequate legal notice of a rent increase. Tenant has a right to terminate a rental agreement if the landlord just barges in without the tenant's consent, if they fail to provide legal notice of a rent increase, a landlord locked out the tenant. And that's one of the specific provisions in the code, that if you're locking someone out, or you're cutting off utilities, that actually involves an unfair deceptive trade practice, which has much more severe consequences and penalties associated with them. Under Hawaii law, if you engage in an unfair deceptive trade practice, it's punishable by from the state getting involved, it's $500 to $10,000 per violation. For private litigant, it allows you to get treble damages and attorney's fees. Another basis for the tenant to terminate a rental agreement is if the landlord fails to maintain the premises. The tenant has a remedy of repair in the code. For rent increases, if a tenant's on a month-to-month lease and the landlord wants to increase the rent, the landlord's required to provide the tenant with a 45-day written notice. For tenants on a fixed term lease, the rent increase may be included in the terms and conditions of the rental agreement. And a lot of times it is, the first year is maybe $2,000. And then in the rental agreement, it may say that the second year it'll be increased by 10% or 15% or whatever. Failure to pay rent. Now, this is prior to August 7th, 2021, and what we're experiencing now with Act 57. I'm not going to go into Act 57 in a great amount of detail, but I'll just talk in general about what the existing law calls for that's sort of suspended right now. So the landlord may demand payment of rent anytime it's due. Notify the tenant if payment is not made within 5 business days after the tenant receives notice. The rental agreement will be terminated. And at that time, the landlord may sue to evict the tenant. This is Act 57. I think you folks, from my understanding, have already covered it somewhat. If not, we can discuss it maybe in more detail during the question and answer period. So if the tenant doesn't maintain the dwelling unit properly, the landlord can notify or should notify the tenant in writing of the non-compliance. And they can specify in these particular instances that no less than 10 days that the tenant has to correct the non-compliance. If the tenant doesn't correct it, the landlord may actually terminate the rental agreement. If the tenant violates a obligation known to them at the time of their entry into rental agreement, landlord may notify tenant in writing of the non-compliance. And this explains what the procedure is. Again, you can terminate under certain situations. Now, terminating a tenancy, these are issues that we deal with. This is a slide that kind of sets out the whole procedure in which the summary possession, formal summary possession process involves. The most critical point of this whole thing that from our perspective is that tenant doesn't show up at court and landlord gets a default. My understanding is that happens very often. Tenant may actually have legitimate defenses, but if the court doesn't know about it, the landlord's position is the only position that's going to be presented to the judge, and the default is going to be granted. Under a month-to-month tenancy, you need 45 days written notice, and a fixed term lease has no notice requirements in the code. But interesting sidelight regarding this 45 days written notice. When Act 57 went into play, it really wasn't contemplated that some landlords were going to be using the 45 days notice instead of the procedures that Act 57 set forth. But my understanding is that many of the judges are not allowing landlords to go forward with the 45-day notice procedure in those situations where it's just the summary possession is based on non-payment of rent. I mean, Act 57 was passed to address all of the issues associated with the non-payment of rent related to the pandemic. And a lot of judges are concerned that maybe some landlords and their agents would try to circumvent it by filing under the 45-day notice rather than the other provision that exists in the code for non-payment of rent, which under Act 57, I believe, is a 15-day notice. Again, this is setting forth some of the time periods that's set forth in the code. The tenant, breaks a lease, they're responsible for rent until the end of the lease term, until the unit can be re-rented, plus a reasonable commission to do so. One way to prevent this from happening, obviously, is if the tenant has a conversation with the landlord. In this housing market, many landlords are actually delighted if a tenant does break their lease so they can have someone else in there. Again, they will ask for cooperation from the tenant to show the unit. Issues that we get all the time involve security deposit. Landlords can't just be imposing security deposit for any arbitrary reason. There are specific reasons in which they're entitled to retain a security deposit to compensate for damage, and that's damage to the dwelling beyond reasonable wear and tear. What's reasonable wear and tear? It's it's a fact-intensive exercise to make that analysis. They're allowed to retain the security deposit to clean the dwelling unit or have it cleaned. I mean, in my view, if a reasonable cost of cleaning a unit is $400 or $500, they shouldn't be charging $3,000 to do it. They can retain it for unpaid rent, unpaid utilities, and keys or fobs that aren't returned. And proper use of a security deposit would be to retain it for issues such as appliances that are damaged or not working. It has nothing to do with the conduct of the tenant or the tenant's guest. And the security deposit can't be used as a final month's rent unless agreed to by both the landlord and the tenant. And these are some of the other issues associated with the security deposit. If the landlord doesn't return the security deposit, the tenant may bring an action in small claims court. And if it's determined by the judge that the landlord wrongfully and willfully retained the security deposit, the court can award the tenant up to 3 times the amount of the security deposit as damages. So again, this is the information regarding our residential landlord center. And this is other information regarding other assistance that you folks may already know about involving legal aid, and also the judiciary has access to the justice room. And again, I'll be happy to address any questions after the next presentation. Thank you for your attention.
Aloha, everyone, and good afternoon. I will queue up my presentation, which we hope will go through some of the issues that Stephen shared, and we can work through them together as a group with some examples. So I know we can't all chat or see each other's faces, but maybe think through what you would do in some of those issues. Danny, can you see it in presentation mode?
Yes, I can. Thank you.
Thank you. As Stephen discussed, there are some common tenant question themes that I think for us, especially as attorneys, we get through the program. And so I'm going to specifically focus on some of the themes that we see where people are seeking legal intervention. So it might be something that for them, they've read the tenant handbook or they've talked to some individuals and they're not sure if this applies to them. And again, I strongly recommend all of you have copies of the landlord-tenant handbook. It's such a great resource, even for me to look back on and figure out which statute is this again. So the first thing that we get a lot of questions about is the 45-day notice, that a landlord can just issue a 45-day notice for someone to vacate a month-to-month tenancy. And I would say the majority of people that we see as clients, even myself as a renter in Honolulu and my friends, are on month-to-month tenancies. And so these are something where if the landlord wants to have the tenant leave the unit, a 45-day notice is what's required. No cause is needed. It doesn't matter if you've lived in the unit for years, maybe you previously had a long-term tenancy. It depends on what you have right now. And as Stephen highlighted, no notice is required under law. If you have a longer term lease, that's when you already know when that lease is going to end. And that's something where we get a lot of people calling with confusion. And we can go through some more examples of how people do get confused. But in general, you need to be the one to communicate with your landlord to find out, are they going to let you convert to a month-to-month tenancy? Are you just going to keep paying the rent? Are things going to end? And so we strongly recommend that's where people at least know that there isn't a requirement. Your lease ends when it says it ends, unless you talk and communicate with your landlord about doing something different. A lot of people may have issues that they feel they want to work out with the longer term tenant, but there is the risk of being called what is a holdover tenant. And if you stay longer than your tenancy, you can run the risk of being responsible for more than the normal rent that you would pay. Another issue that we talk a lot about is eviction. And I know Stephen highlighted how many people don't show up to eviction or maybe don't understand what eviction is versus notice that you're getting. I think we use the word eviction to mean a lot of different things, even myself as an attorney, but specifically for lawyers, eviction is a court process where there are records and it's something you do need to go through. What we find in our program, and we practice a lot of what we call preventative law, which is trying to avoid that court. I would say for law, for those of you who are in health professionals, law is like, the court is like the emergency room. And we're always trying to do something and get a little bit before we end up in court. And that's because court has information. You can search on eCourt Kokua, which can be a good thing. It means that if you have clients or tenants or yourself or family members asking you about things, you can search on eCourt Kokua and find all the court records. But for a lot of people that we serve, that's the thing they're most worried about, that this is a court record that's visible to future landlords. So whether or not they win or not, or if they have legitimate issues that they want to bring up in the eviction process, I think for a lot of the people we work with, this is their biggest fear. And us as attorneys, we want to try to alleviate that fear, that when people do have a claim, it's something they can work out. But we cannot say anything about whether or not future landlords will use that information to screen their tenants. As Stephen illustrated, the eviction is 2 steps. And there's the summary possession, which is what we get a lot of people don't show up for. Summary possession is the ability of the landlord to get into the unit. And that's where a landlord can't make anyone leave the unit unless they have this court order, this summary possession, and then it can be executed by the sheriffs. So if people are getting locked out of units or landlords are telling them that they can't come in, that's not allowed unless they have that. But the most important thing is if your landlord has already done a summary possession when someone's still worried about what is going to be visible to future landlords, it's in their best interest to show up. Because the other part of the case is damages, which is when they talk about how much do you owe your landlord because of past rent that you didn't pay, your landlord's attorney's fees, costs for filing that court claim. So if your landlord's already going through that process, it may a lot be in your best interest to show up for court and to go through the process so you don't get someone deciding what the damages are without your input. And as I suggested, we don't have eviction expungement. It's something that we as advocates have been pushing for. Other areas and states allow it. And in particular, a lot of people have decided to allow it for COVID-19 so that people don't have a COVID-19 eviction on their record that prejudices them for the rest of their lives. And I'm going to a little bit touch on illegal housing actions. So the fair housing issues that we want people to not say, oh, this is what a landlord can do, but to kind of have your antennas up if you think there's some illegal housing actions that a landlord's trying to push through. And these are kind of the themes that we have seen, at least during COVID, of fears people have and common issues that would make them want to seek legal assistance. So I have a bunch of issue spotting questions or hypotheticals that I want us to go through. So when we go through them, I would say the best things to think about are, is this about back rent or unpaid rent? Did the landlord give proper notice? And what does the tenant want to do? And I think that's what's really important is sometimes the tenants know the best. I have found their relationship between them and the attorney and them and their landlord. And so we want to make sure that we see what they want to do, what they think is the best use of their time and resources. Is the landlord just giving notice to vacate the unit? Is the notice proper? Or is this about rule violations? And so these are the informations you might want to have if this is about rule violations. And then, like I said, if there's some other underlying issues that might feel illegal. So if a landlord gives a tenant a letter to vacate their unit within 45 days, A lot of times we still get people trying to seek legal assistance for this. And I'm not saying you shouldn't, but I think there's something to think about when you're issue spotting and trying to decide how could you help a landlord, sorry, a tenant, someone you're working with, your family members. If there's no allegations that someone's behind on rent, or there's no kind of rule violations that the landlord's saying, they're just saying you got to leave the unit in 45 days. Doesn't matter how long you've been there. There's no allegations of rule violations. What you have to think about then is it proper written notice? So the first thing I would think about with 45 days is who gets to have 45-day notice? That's for people on a month-to-month lease. And is the notice properly written? And you can look in the landlord tenant handbook that has some examples about it. There are ways that you could fight in court and say the notice isn't proper, if someone really wants to fight that in court. But sometimes I feel that might not be the best use of people's time unless they have a very different relationship with their landlord, because the landlord can just refile the proper notice and get the person out in the end. So one of the best things that I think people can do is to assist with maybe mediation to have a move out date if they really don't think 45 days is enough, and try to agree to a further move out date. Otherwise, you have to be out of those 45 days. That's kind of the requirement under law. Let's say a client is 1 month behind on rent and they want to apply for rental assistance. Again, what I said, our focus has been not necessarily on immediate legal intervention at court, but to say, how can we assist someone with navigation to social service providers, even if their landlord has not given them that notice, they're behind on rent. Let's make sure that we can get together the documents to prove they applied, show that they're trying their best to pay that rent. And I think during COVID, what we've seen a lot of is that a lot of people are trying so hard to get rental assistance, and there's been a miscommunication or breakdown in communication between them and their landlord, who may often feel that the tenant's not doing enough. And maybe they just don't know how difficult the process can be. I would especially point out that for landlords, if someone's only 1 month behind, I know you saw in the earlier session, the landlord cannot file until January. So it'd be really important to see about trying to do mediation sooner rather than later, and maybe try to get the landlord and the tenant on the same page. So a landlord gives a tenant a notice to leave. It does say it's because of unpaid rent, and they give some information about mediation. This actually sounds like a situation where they probably did give enough notice. So what you would want to know is the notice correct? Does it have the complete information? But the most important thing is that we've seen, even though there were law changes that allow longer length of time for notice for unpaid rent, some landlords don't know about that yet, and they're just using the regular old notice. So for a lot of people, we've seen tenants not be given the full 15 days that they're allowed. They've been given 5 days. And there's been, not enough time for those tenants to be able to schedule mediation. So that's something where I would suggest to see what you can do to help and make sure that the notice is correct, okay? Is the tenant interested in fighting this in court? Do they have prior evictions? And that's something that a lot of people are worried about, their record. And then what's really important for a lot of people is if they have a voucher or assistance, and they're a lot of times worried about if their eviction court records could have something to do with that voucher. But what I would strongly suggest you to think about is if they have a voucher, they probably have more protections. There's probably something more that can give them some a little bit more help and assistance. So that's why I'm calling these issue spotting, is sometimes there's not really the exact answers, but just issues to spot when you see someone that's something that looks pretty straightforward, but it might not be. Okay. Here's another common situation that we've had. Someone may have lived in the apartment for 10 years, and every single year their landlord has approached them to extend that lease. But during COVID, maybe for the first time in their lives, someone had to rely on rental assistance with their landlord and really have financial inability to pay. So maybe the landlord accepted the rental assistance, they're getting some help, but the landlord doesn't want them anymore. They know that they're getting close to their, well, maybe they don't know, but they know they have a couple more weeks to the end of their lease, and the landlord hasn't said anything to them about extending a lease, not like they did before. And this is a situation where I think it's really good for us to work, maybe as service providers, to start conversations early, because otherwise the tenant should not take anything for granted, that maybe the landlord does want them out of that unit. And so they really need to start those conversations together. Okay. Here's another one that the landlord signed 1-year lease. This is, I say, the most common situation we see after the lease expired. Maybe they didn't have those conversations, but they just kept paying rent and the landlord didn't say anything. And they've lived there for 5 years, just paying rent per normal. This kind of situation, if they got a text from the landlord saying, hey, you know what, you need to move out now. They don't tell them why. Well, first of all, this is a text. I don't know if that would qualify if it's a text, but they are, if they're giving them 2 months, you know, that is beyond the 45-day written notice. So it might be someone to decide, do they really want to challenge that written notice, or do they want to say, hey, at least my landlord's giving me more than notice than is required? But there is this other thing in law, which is if you know that the landlord is going to convert your unit to a vacation rental, they're required to give longer notice. And so that might be an issue to think about. What's going to happen to that unit? Does the tenant know? Okay. All right. I'm going to skip through some of these. Sorry, because I know we don't have time. So here's a situation we see a lot too. A tenant's unit has been eaten by termites. They actually notify the landlord in writing and say, we are going to, you know, the unit needs to be sprayed for termites. Maybe there's some doors that need to be repaired and we think it's a security issue. And the landlord just says, I don't care. If you don't like it, don't live here. That's why it's so cheap, because, you know, I'm not going to spend money on this unit. So the tenant maybe reads the tenant handbook and they give them a letter, and it says that they are going to repair the doors themselves. They are going to set aside some of the rent, and they are going to use that rent money to install doors themselves. As soon as the landlord gets that letter, they give the tenant a 45-day notice to move out. It says, sorry, you have to move out. So the tenant did use their right to self-remedy by notifying the landlord and saying they're going to use money to repair the unit. And that's something that a lot of people aren't even able to do. They may not even have that extra money, and it's kind of a scary situation. So if you have a tenant in that situation, I'd strongly recommend that they seek an attorney or legal advice, because retaliatory evictions are not allowed under law. And so the tenant is probably going to have to fight this in court, and it's going to be a court claim. And so for a lot of people, a court claim involves a legal record, and that's the thing that they're most worried about. They think a future landlord is going to see that I had to deal with my other landlord in court, so they're not going to want me. And so that's why we really do want to see about having eviction, and even expungement for certain things. And then the thing that I think scares a lot of people away, but it's something that we really have to talk them through, and why I think they need guidance of a good attorney, is that if you lose a claim in court, you could be on the hook for the attorney fee payment for your landlord. And so that's why I think it's good to seek out good legal advice so that we can assist a tenant with thinking about, is this right to repair something that I want to fight? What could be my damages? What kind of claims could I get? What is something that, is it worth that risk for me? And help them manage kind of that risk about taking one of those claims to court. Okay. So I would suggest making sure someone has access to an attorney. Okay, so for my last issue spotting, and this is where we start to see things like I'm calling hidden discrimination. And that's where you maybe have a landlord that tolerated different rules violations in the past, but a family, they start to feel like they're being targeted, that they're getting a notice for rules violations, but a bunch of other neighbors aren't. Nobody else is being targeted in that way. Is it because they were behind on rent and they had some financial problems? So now the landlord is going to say, nope, you're violating the rules, like you have pets or you have something. The thing to think about, is there possible discrimination? What is the basis of this unequal treatment? And for those of you who've maybe had civil rights trainings before, you know, the issue is thinking about is the unfair treatment related to a protected class. And so we're looking for a protected class and kind of an action. And so under our state law, the protected classes are people who are ethnicity, color, national origin, family status. That's something some people don't know, whether you have kids or not. So having different rules for families with kids, sexual orientation, marital status, ancestry, age. And as Stephen mentions, protected classes can be expanded through law and bill change. That's where we've expanded domestic violence to be a protection, but that is only for employment. And source of income, which means if you're having financial difficulty, that's not a protected class. So the landlord could use your financial situation or the fact they peer you're poor to evict you. So the actions can be steering you to certain units, unequal rules, unapplied rules, refusing to rent to you. So we'll go back to that issue that the landlord tolerated the family, the rule violations in the past, not just for the family, but for everybody else in the building. And there even are some other people who are behind on rent and the landlord's not saying anything to them. So I would say what we need to look for is the unfair treatment related to a protected class then? Does this family feel like, hey, maybe I'm the only family? So that's why maybe I'm the only Pacific Islanders in the building. And that's where we think the landlord's trying to get us out. So here's another type of situation that we hear. There may be a Native Hawaiian or Pacific Island family who's receiving rental assistance. And, you know, yes, that is about them receiving rental assistance, but, you know, the landlord says, I'm going to evict you anyway, because I think it's going to get too overcrowded. You're going to have family members come and stay, and it's going to get too noisy. So these are the type of situations we see where it's kind of mixed up. You're not sure. Is this about the fact that they're a family? Is this about the fact that they're receiving rental in assistance? Or is it that it's about them being noisy and violating rules? Oops, sorry. I would say that this could be possible discrimination. And if you have a family in this situation, then I would suggest to evaluate this as discrimination and send the case, which I'll have on the next slide, to the Hawaiʻi Civil Rights Commission, because this is about stereotypes. It's about stereotypes of families, stereotypes of maybe Native Hawaiians or Pacific Islanders. It doesn't seem to be specifically about them receiving the rental assistance, but stereotypes about people and their families. This is something that is more straightforward. A landlord tells a family they're not going to renew their lease because they believe they're not going to be able to pay rent since they relied on rental assistance. So the same as the previous situation, but they tell them straight outright, I don't think that you're good for it. And that is income discrimination. It is not yet protected under law. But we do know, just like the first situation, sometimes people use it as an excuse to deny tenants when really it's about stereotypes that might be about race, family status, gender, a single mom, that kind of thing. Okay, so if you do have a client or someone that you think is dealing with a Civil Rights Commission, a possible discrimination, you can always send them the pre-complaint questionnaire or PCQ to have it checked out by the Hawaiʻi Civil Rights Commission. They have intake staff that will contact people. They are a neutral third party who investigates claims of housing discrimination. You do not need a lawyer, and the staff can assist people through the process. Okay, we at the Medical Legal Partnership have a bunch of slides about landlord-tenant law on our Facebook, our website, our Instagram. And so some of these are specifically about COVID themes, and there's something we recommend that you can all share with each other. On that note, I'm going to end, and thank you, everyone.
Thank you, Deja. Thank you, Steve, for sharing all of that information. We do have a few questions that we wanted to go through before we end the session. There's a couple questions on subleasing to like subtenants. Does the residential landlord-tenant code have provisions on subtenants? Example, a renter sublets the rooms out of the house after non-payment of rent. The tenant was evicted. However, the subtenant was left behind and doesn't want to leave. Do they have any rights?
Sassy, do you want to take that one?
You need to unmute, Sassy. Sorry, you're muted.
Sorry about that. Hi, everybody. The residential landlord tenant code does address the issue of subleasing. Okay, so what it actually says is, landlord, if you are silent in your rental agreement about do not sublease, then really the tenant can sublease. If the landlord can also put in, you can sublease, but with my permission. So in a situation where I'm a tenant, I'm not supposed to sublease, but I need some help with my rent, so I'm subleasing to someone. Now I've become a landlord. However, my landlord doesn't know about this person. So if I leave, this person probably is not a tenant. So they are vulnerable in the landlord filing for an ejectment, which is a process to get somebody out that's not a tenant. I hope that answers that question.
Okay. Earlier today, Legal Aid shared that a homeless facility and programs authorized by part 17 of Chapter 346. HRS are exempt from the landlord tenant code. However, it seems that specific part only applies to programs funded by the DHS Homeless Programs Office. So if a shelter is not funded by DHS Homeless Programs, does this mean it is not exempt from the landlord tenant code?
The code just merely says homeless facility. That's all I can tell you. That's written in there, and I can't interpret it for you.
I will say as well that generally homeless services, so if someone's residing in a shelter, and I think this is a huge gray area and we do get a lot of questions about it. So if someone is having some issues, to contact an attorney. So homeless shelters a lot of times are considered services, even though we know that, say, for example, if families residing in Next Step Shelter, they're paying a fee to reside there, say $60 to $100. The things that become different are, say, someone's in a transitional shelter and their monthly fee payment goes up to, say, $400, $500, $600. Some of the other things that people see as shelters, such as Kahawiki Village, that is under the landlord tenant code. That is operated by a private, I don't know what to call it, a private company management. Property manager. So that does apply to the landlord tenant code. That is a housing situation. It's not a situation of, like, say, transitional homeless services. But I know that it can be a very difficult and thorny issue to navigate. And so I would suggest seeing an attorney if someone has issues, depending, likely if it's an attorney that's worked doing a lot of people in poverty, they probably know and are familiar with the project and kind of how that project works. But I have been concerned as an attorney when I see a lot more of those different projects being for people who are given, they're only awarded through the coordinated entry system through CES, but then people start paying rent and it looks a lot more like a landlord tenant situation rather than a homeless services situation.
So
if
like
you have a situation, reach out to us, please. Thanks.
So like specialty shelters like Tutu Birds, are they exempt from the landlord tenant code? Those medical respite places?
Yeah, I think Tutu Birds is considered a services one, but I don't, please don't quote me on that one. It really depends on looking at the service agreement, and it does get to be a gray area.
Okay, I think there's one more question. What is a utility allowance deposit? And is it legal to include it into the security deposit? The utility allowance deposit.
Can you include utilities in the security deposit? Is that the question? I'm sorry.
So I think the question is the utility allowance deposit is included in the security deposit amount. Are they able, is that legal to charge it like that?
You know, my answer to that would be whatever the landlord is wanting to throw in there, all they're allowed is 1 month's worth of rent for security deposit. We may not know if that's for utilities or what they're planning to do. The code has specific guidelines on notification. So the landlord has to tell the tenant what the money was used for.
Yeah, I would say if there's, there are agreements I've seen, I know this doesn't require a deposit, but for say there's a landlord who's given, and we see this a lot, they're a room in a house, and so they're unable to cut off who uses what utilities. And so sometimes they might have a utility allowance of how much, the person has to pay in their utility amount per month. So say they have the rental amount and then their utility amount. And I have heard of tenants complaining that their landlords do aggressive, and it does sound borderline illegal behavior of monitoring how you use utilities. I know when I was a renter too, I had a landlord who would monitor whether or not I used hot water in the washing machine and make a deal about that. Those things start to sound like they're not part of the rental agreement, and that if the landlord, that they can't be pushing you to take on this other utility responsibility that's beyond what is in the rental agreement. The rental agreement should be you pay your utility allowance and you pay your rent, and that's what it is. It's up to them. If they don't have a separate meter, that's their business decision. So I would say that if it's like about paying a monthly utility amount.
Okay, I know the presentation's being recorded, but people are asking if the PowerPoint will be accessible after the conference.
Yeah, let me know who to send it to. I can send my
Okay.
PDF slides.
Okay, we'll do. I don't see any more questions unless you guys have anything else you wanted to share.
If I could just make a couple of comments. The presentation Steve and Deja provided had kind of a similar thread, and that is if you're working with clients that are facing issues with residential landlord situation, please start a dialogue with the landlord. Talk to them, figure out what's going on. Some folks may be embarrassed because they weren't able to pay the rent, but they're probably going to be able to pay the rent next month. So communication is super important. The calls that we've received have often involved, I have a fixed lease, it expires next week, I don't really know if they're going to renew it or not. Really, when you sign up on a fixed lease, you're going to know the beginning of the lease and you're going to know the end of the lease. So, trace your calendar or whatever and have a conversation to benefit not only yourself, but the landlord as well, right? Because since the issue is silent, the landlord's probably wondering, are you going to stay? Are you going to go? They're not really sure. And just also FYI, if you don't know it already, a month-to-month tenant can happen when you have something in writing that says you're on a month-to-month, or most of the rental landlord relationships, you have nothing in writing. And when you have nothing in writing, you are automatically on a month-to-month. So that's something that's good to know. Thank you.
Thanks, Sassy. I think that's it. Everyone's just asking for a copy of the slides so we can get that to everyone after the conference. But I don't have anything else. Thank you all for sharing your knowledge and expertise. We appreciate it. For those that are still on, we have one more session at 2:45. It's the Federal Strategic on Ending Homelessness. If you guys want to jump on at that, that's at 2:45 p.m. But thank you all for joining us. Have a good day.
Thank you.
Thank you.